Hey gang, trial lawyer Ryan Pastiga for episode 2 of the Minnesota Trial Law Report. And we're going to kick things off right away with the Vance Bolter plea deal. So, most murder cases in Minnesota happen in state court and people are charged with a state murder, right? And that's 99% of murder cases. But once in a while, the feds will charge a murder out. And that's what happened in Vance Bolter. And he was the guy, of course, or is the guy, that was charged with murdering former House Speaker Melissa Hortman and her husband, and also attempting the murder of Senator John Hoffman and his wife. So, death penalty was originally on the table. What was going on here is that this case was probably steamrolling right towards a trial because the death penalty was on the table. But recently, the federal government took the death penalty off the table. And what came together pretty quickly after that, of course, is that today he's scheduled to plead guilty in federal court and avoid the death penalty. So you might kind of wonder, well, why in the world would the federal government give up the death penalty, especially if there's a case that seems to have a lot of really good evidence and that it shouldn't be that hard to get a conviction? Well, there's a number of reasons why, and these are just some of them. That things that trial lawyers, whether they're prosecutors or criminal defense lawyers, will consider. Number one, a death penalty trial is very expensive. It takes a whole lot. There's a lot more procedures that are involved. There's different phases of a trial, and that will cost prosecutors and their staff time and money to put together a case like that and be in a trial for very long. Second, that takes the courts a lot of time and money and jurors a lot of time and money. So even if prosecutors think they can get a conviction for the death penalty, they have to weigh out, is it worth that versus a penalty of life in prison without the possibility of parole? How much more are they getting out of it if they get death or not? That's just one thing they consider, and the time and money that's involved. Second, there's always the risk. There's always a risk that a jury does something that even the prosecutors think they got a real solid case that they weren't planning on. Whereas a plea agreement to, let's say, life without the possibility of parole gives them an absolute assurance that there won't be any appeals, that the conviction is going to stand final, and that the person is going to get out of there with a not guilty verdict or what's called a mistrial, which is another thing that can happen. You can have a trial, and even if you have 11 jurors thinking guilty and one finding not guilty, that's called a mistrial. A jury verdict or a conviction requires a unanimous verdict, both for not guilty and for guilty. Anything other than 12-0 on either side of it, 12 guilty, 0 not guilty, or 12 not guilty and 0 guilty, that's called a mistrial. So 11-1, 6-6, you name it. And of course, that would mean that the parties would have to do a new trial, starting over all the way over with a new jury as well. And that gets expensive and exhaustive. And finally, of course, a lot of times the prosecutors will ask what the victim's family wants, right? Do they want to go through the length of a case until it gets to trial? Do they want to go through the trauma of a trial? Because it's hard to be cross-examined if they're witnesses. It's hard to be sitting through day in and day out of the very emotional parts and reliving some of these things in a case. So sometimes they're like, hey, we don't want to go through that. And if the defendant will plead guilty to something like life without parole, that's worth it to us rather than having for us to have to go through a trial as well. So these are just some of the things. And there's another thing. It takes me back to the Jacob Wetterling situation a few years ago. The defendant in that case was also set, I believe, for a death penalty, if I remember correctly. And his federal defenders at the time worked something out where if he gave critical information to the prosecution, the United States government in that case, things that weren't known to other people, that helped bring some closure to the criminal investigation there, as well as, I think perhaps, I don't want to speak for them, but maybe some closure to the victim's family as well in that case. And I don't know if that's what's happening in this Bolter situation as well, but there may be some things. There may be some things that the prosecutors and the FBI and other agencies want to know about that Bolter certainly probably wouldn't talk about without a plea, but there might be a backdoor agreement, I'm just speculating, where he agrees to provide some information. Maybe there were other people that assisted him in doing what he was doing. Maybe there's things that are hidden that the prosecution still doesn't know about and they want to get this whole investigation right. It's just possible, not saying it did happen, but some of these things can happen behind the scenes with lawyers and with federal agencies that are investigating crimes, and this can bring it all apart a plea deal, or bring to the table a plea deal that says, tell you what, if you tell us X, Y, and Z, we'll agree not to seek the death penalty. So these are just some reasons why a death penalty can come off the table in a prosecution. Of course, there's another thing. Sometimes prosecutors, if they see a problem with their case and they're not so sure that it's going to go their way, if they go to trial, that's another bargaining chip as well. So that's he's scheduled to plead guilty today. Might be happening as I'm actually filming this episode too. Second, I want to dispel a myth out there. I represent Greg Morgan. He's an ICE agent that was charged in Hennepin County District Court with 2 counts of second-degree assault. There's a law that says that if there's a federal agent charged with a state crime, that federal agent can petition a federal court to have that case removed to federal court. Here's what's happened. We filed the petition in that case, and here's what happens next. When there's a petition like this filed, it's not an automatic right to have the case moved over to federal court. What the federal judge then has to read that petition and determine whether there's a colorable federal defense, and some other standards have to be met. And if, based on what's written in that petition, there's enough to qualify for an evidentiary hearing, then the federal judge will order an evidentiary hearing, and things will pause at the state court at that time for a little while. If, on the other hand, the judge reads the petition and says, you know what, you haven't raised a federal defense, or just everything you've written on the petition isn't good enough to even get an evidentiary hearing, then the judge can reject the petition and just everything stays in state court. But if the judge grants an evidentiary hearing, then an evidentiary hearing can happen. There can also be a motion to dismiss by the defense. And of course, if the judge does not throw the case out, the federal judge, because of supremacy clause immunity, then sometimes that case can actually go to trial in federal court, but with the state court prosecutor still prosecuting the case. It doesn't turn over to a federal prosecutor, and the state court crimes don't become a federal crime just because the case gets moved over to federal court, which, here's the myth I want to dispel. Some people think that if a federal officer is allowed to remove their case to federal court, their state charges to federal court, that would give a president power to pardon the defendant even if there's a conviction, and that's not actually true. A president can only pardon federal crimes, not state crimes. So, in this situation, even if the federal court grants the petition and the case is removed to federal court, the president would never be able to pardon this case. Rather, the case would still proceed in federal court. The only people who can pardon, if you will, a state court crime would be a governor, not a president. If it was a federal crime, then the president could pardon. But by virtue of a state court case getting removed over to federal court, it doesn't convert the alleged crimes from state crimes to federal crimes, and I want to dispel that myth for people out there. Okay. Third, there's a case going on up in Roseau, Minnesota, and these are the reports. A woman was allegedly driving, and some people were calling into the police saying her driving, she's weaving all over the road. Well, eventually there's a head-on collision with another vehicle, and at one point this defendant apparently told law enforcement that her dog kind of hit the steering wheel, and that's what caused her vehicle to go over the center line and get into this head-on crash where someone was killed in the other vehicle. And here's why that's important. It's alleged that she had a number of medications in her bloodstream, prescription medications. I do not know if these were prescriptions that she had a valid prescription for, or whether they were typically prescription drugs, but she didn't have a prescription for them. But what gets important is, even if someone does have prescription or drugs in their bloodstream, the government still has to show negligence. If they're alleging impairment, they also have to show negligence to get a conviction. And what the interesting twist in this case would be is it negligent for a driver to be driving a vehicle if a dog kind of jumps across and hits the steering wheel, and that's what causes a vehicle to go into the other lane? And that's where this defense kind of gets really interesting here. You can be impaired with prescription medication. You've got an affirmative defense if the prescription levels in your blood match what your prescription levels were. But if your bloodstream shows that you've got way higher doses of a prescription that you have a prescription for than what was prescribed for you, then you don't get to use that defense anyway. But what we're really focusing on with this dog situation is, does this factor in that the prosecution's got to show impairment and negligence, and can this defendant beat that charge by arguing to a jury that she wasn't negligent when she was driving because it wasn't her impairment that caused her to cross the center line, but rather the dog hitting the steering wheel and going over the center line. So we'll keep an eye on that case. And finally, what we can talk about is two other things. One, getting over to the civil side of things. I was at a national trucking law college within the last month here, and we're talking about safety standards, especially for some trucking companies that are hiding evidence, right? So trucking is a very regulated industry, and the reason is, of course, because these semi-trucks can weigh up to 80,000 pounds when they're fully loaded, and when they're barreling down a highway, they can be very dangerous if they're not driving safely, or if the equipment on them is not maintained and inspected the right way. And if that equipment fails, even if a driver is doing their side of the job, that can also be very dangerous because the semi-truck can go off the road and things like that and kill other people, right? So as I'm driving down the road, I'm looking ahead, and there's this semi in the right lane. It's a 2-lane highway I'm going down, and this thing is driving all over in the lanes, into my lane, onto the shoulder, back into the middle of their lane, back into my lane. And I'm thinking either this driver is having a medical emergency like a heart attack or something, or they're distracted. Well, eventually I get up alongside of the thing and I look up there, and there's a driver on a cell phone. And we're talking about how these crashes can happen. Now, these semi-trucks have cameras inside of them, and most of the time the cameras are two-way cameras. They will point ahead and show the road ahead of the driver, and they also point at the drivers inside of the cab, and that is to show, hopefully, that these drivers are being safe, or they can be monitored if they're not being safe. Well, these drivers sometimes get real smart. What they'll do is they'll put their cell phone, there's a curve in the steering wheel, and they've learned to put their cell phone in their thumbs and lean it against the steering wheel, and it kind of is hidden from the camera that way, and they can be looking on their phone and get distracted watching movies and things like that. So that's one thing that can lead to them driving that way. Another thing that can lead to them driving that way is if they're fatigued. So they are regulated with how many hours they can drive in a day, and the reason is that the studies show that after a certain number of hours on the road, a driver's likelihood of either falling asleep or not being able to pay attention as well really increases. So it's not a graph. Think of a line on a graph. It doesn't go like this with the number of hours driven and the fatigue factors. It kind of goes like this, and it shoots up after a certain number of hours, and that's generally the cutoff in a day for these semi-truck drivers, and after that they can get real dangerous. Well, what we see in these trucking cases is that sometimes the drivers or the semi-truck companies or the insurance companies will manipulate the logs. They used to be handwritten logs. Some companies still use them, but they're supposed to be electronic logs nowadays. But there are ways, you'll even see some YouTube videos out there where some drivers are talking about ways to fool the electronic logs and make it look like they're only driving the certain number of hours that they're supposed to be driving and not driving in excess of those hours, but they're fudging on these logs. And what lawyers who are concerned with the safety in these trucking cases are doing are learning ways to find out when these logs are manipulated, or when these companies cut other safety corners which put other motorists on the road in great danger. Things like exploding tires because the tires weren't checked in a pre-trip inspection, and they go flying off in the middle of the highway and can go right through a windshield and kill somebody, for example. Or some other safety equipment that these trailers, I saw a trailer that was missing some safety equipment on it, and the trucking company decided to keep that truck rolling down the highway because it would cost them a little money and they'd have to wait to repair it. They want to keep making money, and the way they keep making money is keeping their trucks rolling on the highway. And so they were putting profit over the safety of their citizens, And what we're seeing is when juries are finding out about some trucking companies doing these things, they are awarding big verdicts for people who are seriously injured by these trucks or these trucking companies or these insurance companies that are hiding information, or of course, unfortunately, for the families of some of these people who are killed by that. So anytime these trucking companies are putting profit ahead the safety of people and juries are finding out about it, they're talking in the only language that some of these trucking companies understand, which is money. There's a lot of good truckers out there. Some of them, unfortunately, even work for bad trucking companies. And those truck drivers are being pushed to drive beyond the number of hours they are, or they're getting threatened that they're going to get fired if they don't and everything. So it's not always the truck driver's fault. Sometimes it's a dirty trucking company. Other times you've got a trucker that wants to cheat themselves. In either case, it's unfortunate because what happens is that innocent motorists are getting killed or life-altering injuries as a result of these unsafe practices. So we keep an eye on them and we keep peeling back the layers when these cases hand up to get to the truth, because that's what the juries want to know about, and they are penalizing these companies if they're cheating. Okay, finally, government liability and damage caps. Did you know that if somebody sues a governmental entity and they go through a jury trial, that a judge can cut down the jury verdict afterward? Here's what can happen. So a jury hears a whole trial. They hear from experts testifying. They consider damages. They deliberate about these things, and they'll issue a verdict for a family, right? Let's say it's $4 million or something. What you might not know is that there are laws that limit a governmental entity's liability and force a judge to cut down the jury verdict afterward without even telling the jury about it. So it could be like a jury says, hey, $4 million is what's right for this person who was catastrophically injured. And the judge says, okay, after the trial, well, lawyers, I got to cut down the jury award to $500,000 because the legislature has made a law that says that a governmental entity in this situation can only be responsible to a maximum of $500,000, no matter how high the jury verdict is, and it gets cut down. And people aren't aware of that, and I just want to make you aware of that. So I'm Ryan Pasiga. I'm a trial lawyer. I follow and do criminal cases and serious injury cases, and I'm going to keep updating you about some things that you might not know about the law. Let me know. I hope this was helpful for you. You can find me at mntriallaw.com or call me at 612-339-5844. Take care.